And we're following breaking news. Kilmar Abrego García is still a free man after a scheduled check-in with ICE in Baltimore today. A federal judge granted a temporary restraining order this morning, barring the government from detaining him again. That judge released Abrego García yesterday, saying he couldn't be held in an immigration detention center because he was never given an official removal order. Abrego García spoke alongside a translator earlier this morning.
Y ahora estoy aquí de pie frente a ustedes y la lucha seguirá. Yo seguiré de pie, no le bajaré la cabeza a nadie. Siempre estaré de pie sobre todas las injusticias que ha hecho este gobierno.
Abrego García was first deported to El Salvador in March. Despite a court order barring that, the Trump administration has repeatedly claimed he's a criminal MS-13 gang member, though he denies that. And now we're learning about a new removal order. ABC's Mola Lenghi is outside that office in Baltimore. Hi, Mola. What's the latest here?
Well, yeah, hi, Diane. Garcia is a free man going home, at least for now. Garcia was here at this federal building in Baltimore this morning, checking in to the ICE office just hours, really, after he was released from jail Thursday when a judge ruled that the Trump administration had detained him, as his attorney characterized it, without lawful authority. There was concern among his supporters that during this check-in at the federal building here this morning that he would be redetained by immigration officials. But as Abrego Garcia walked into the building here in Baltimore, a judge granting his attorneys a temporary restraining order, banning the government essentially from redetaining him, if you will, at least for now. You might remember back in March, he was deported to El Salvador after the Trump administration claimed that he was a member of the MS-13 gang. He was brought back to the U.S. in June to face human smuggling charges in Tennessee, charges to which he has pled not guilty to. He was then released to the custody of his brother, who lives here in Maryland, pending the trial for those Tennessee charges. But again, he was detained by immigration authorities and held in a detention facility in Pennsylvania. Last month, the federal government sought to deport him to the West African nation of Liberia. A U.S. court ruled yesterday that the government did not have a removal order for Garcia, which blocks them from deporting him, at least at this juncture, is the way that they characterize that. Abrego coming out this morning telling the 40 or 50 supporters who had gathered here outside the building today that he believes this is a country of laws, and he hopes that this, quote, injustice done to him will come to an end. Diane.
And Mola, documents obtained by ABC show an immigration judge has apparently added a removal order to his immigration records. What more do we know about that? And does that lay the groundwork now for another potential deportation?
Well, potentially, Diane. Yeah, a judge added that order saying that it was needed in order to correct what was essentially an administrative error from a court order back in 2019. And as that judge put it, that order did not include a removal order, but it should have, according to that judge. And by adding that removal order, as you mentioned, it does potentially lay the groundwork for a future deportation of Garcia, which is why his attorneys were really concerned this morning that he may be redetained. But again, a judge granting that temporary restraining order, preventing any of that from happening. But again, that is a temporary order, Diane.
Federal judge blocks Trump's attempt to redetain an immigrant. What this case actually tells us. Another federal judge has stepped in and said no. Not no to immigration enforcement. Not no to executive authority. But no to the idea that court orders can be treated as optional when they become inconvenient. This case centers on one man, Kilmar Abrego García. He is a Maryland resident, a father, and a man who was granted legal protection by an immigration judge after showing that returning him to his home country would likely put his life at risk. That protection was not informal. It was not advisory. It was a binding court order. And yet, years later, the federal government attempted to detain him again. What makes this moment matter is not just the decision itself. It is how ordinary the government tried to make it feel. No dramatic announcement, no public justification laid out in advance. just a quiet assertion of power, as if prior judicial protection were a speed bump rather than a barrier. The judge who reviewed the case didn't see it that way. The court issued a temporary restraining order blocking the detention, making clear that the government could not simply move forward without judicial review. That might sound technical, it isn't. This is a live test of whether the executive branch must still stop when a court says stop. It is a test of whether individual rights survive only until the government decides to revisit them. And it is a reminder that the rule of law does not fail all at once. It frays when small violations are normalized, especially when they happen quietly. To understand why this case matters, we need to be very clear about what actually happened, without legal jargon and without spin. Kilmar Abrego García came to the United States after fleeing violence in his home country. Like many asylum seekers, he entered a long legal process designed to determine whether returning him would put him in serious danger. An immigration judge ultimately granted him withholding of removal. In everyday terms, that means the court determined the U.S. government is legally barred from deporting him to his country of origin because doing so would likely expose him to persecution or harm. That protection is not temporary by default. It does not expire quietly. And it does not disappear just because immigration authorities later change their posture. It is a court order. Years later, federal authorities detained Abrego Garcia anyway. The government claimed it had new reasons. It suggested changed circumstances. It relied on its general authority to enforce immigration law. But here is the key detail. It did not first return to court to ask that the original protection order be lifted or modified. That distinction matters. When courts issue protection orders, the executive branch does not get to unilaterally decide they no longer apply. The proper process is to go back before a judge, present new evidence, and ask for permission to act. That didn't happen here. Instead, Abrego Garcia's attorneys had to rush back to federal court and ask for emergency intervention. They requested a temporary restraining order, or TRO, to stop the government from detaining or removing him until the legality of its actions could be reviewed. The judge granted that request. In doing so, the court effectively said, "Pause. You cannot proceed until we determine whether you are legally allowed to proceed." That is not a final ruling. It does not resolve the entire case, but it is a clear statement that the government does not get to move first and justify later when individual liberty is at stake. And importantly, the judge issued the TRO because the harm could not be undone after the fact. If Abrego Garcia were transferred or deported, the court's ability to protect him later would be meaningless. That is the factual backbone of this case. Everything else, the legal arguments, the constitutional questions, the broader implications, flows from this moment. The phrase temporary restraining order can sound technical, even minor, like a procedural speed bump. In reality, a TRO is one of the most serious short-term powers a court can exercise. Courts do not issue these orders casually. They are reserved for situations where a judge believes that irreparable harm is likely to occur before the legal questions can be fully argued and resolved. Irreparable doesn't mean inconvenient. It means damage that cannot be undone later. In Abrego Garcia's case, the harm was obvious. If he were deported or transferred while the legal dispute was still unresolved, the court's authority to protect him afterward would be meaningless. You cannot reverse a deportation in practice the way you can reverse a fine or reschedule a hearing. That's why TROs exist. They are not judgments on the final merits of a case. They don't decide who ultimately wins. What they do is preserve the court's ability to decide at all. When a judge issues a TRO, they are saying, "Stop, hold everything where it is. The law needs time to work." That matters because courts are designed to be deliberative. Evidence takes time, arguments take time, and constitutional limits only function if the government cannot outrun them. In a system that respects the rule of law, executive agencies comply with TROs immediately, even when they disagree, because the alternative is chaos. If enforcement agencies could ignore temporary court orders, they could effectively nullify judicial oversight simply by acting faster than the courts can respond. That's not a hypothetical concern. It's exactly why judges treat TROs as binding commands, not suggestions. And that brings us to the unsettling part of this case. The government did not argue that the TRO was unclear. It did not argue that it had already been lifted. It did not argue that Abrego Garcia fell outside its scope. Instead, it argued, implicitly, that executive detention authority continued to exist alongside the court's order. In other words, that enforcement power does not fully stop, even when a judge says it must. That claim, if accepted, would hollow out the very purpose of temporary restraining orders. It would turn them into symbolic gestures rather than enforceable limits. And once courts lose the ability to pause government action, constitutional protections become conditional, applied only when the executive branch chooses to respect them. That is why this stage of the case matters so much. It's not just about one individual, it's about whether courts still have the power to slow the machinery of the state when liberty is at risk. At its core, the Abrego Garcia case exposes a constitutional conflict that goes far beyond immigration law. It's a conflict between executive enforcement power and judicial authority, and about which one ultimately has the final say when the two collide. The Constitution does not give the executive branch unchecked power to enforce the law however it sees fit. That power exists within a system of constraints, and one of the most important constraints is judicial review. Courts are not advisory bodies. When they issue orders, those orders are binding. That's not a courtesy extended to judges. It's a structural necessity for the separation of powers to function. When an immigration judge granted Abrego Garcia withholding of removal, that decision created a legal boundary. The executive branch was barred from deporting him to a place where he would likely face harm. That boundary remained in place unless and until a court modified it. The administration's position in this case effectively attempted to redraw that boundary unilaterally. Rather than returning to court to argue that circumstances had changed, federal authorities acted as if detention authority could coexist with, or even override, the existing protection order. That framing is deeply consequential, because if the executive branch can decide on its own when judicial protections no longer apply, then courts cease to function as a meaningful check on power. They become obstacles to be maneuvered around rather than institutions to be obeyed. This is not how constitutional governance is supposed to work. Under our system, courts interpret the law and issue binding rulings. The executive enforces the law as interpreted by the courts, not according to its own unilateral judgment when it finds judicial constraints inconvenient. That division is intentional. It exists precisely because enforcement power is coercive. It involves detention, removal, and the use of force. Without judicial oversight, those powers are prone to abuse, even when exercised in the name of public policy. What makes this case especially troubling is how ordinary the government's argument sounds. It doesn't announce a rejection of judicial authority. It doesn't deny the existence of the court's order. It simply treats enforcement discretion as ever present, always running in the background. That's a subtle but dangerous shift, because constitutional breakdowns rarely begin with open defiance. They begin with reinterpretation, with quiet assumptions that certain limits are flexible, with arguments that sound administrative rather than radical. If courts have to repeatedly intervene to remind the executive branch that their orders are binding, the balance of power has already started to tilt. And once that balance shifts, it doesn't snap back easily. This is why judges take cases like this seriously, even when they involve a single person and a temporary order, because the question underneath is not narrow at all. When a court says, stop, does the government actually have to stop? One of the most important things to understand about the Abrego Garcia case is not just what the government tried to do, but how it talked about what it was doing. Because the argument federal authorities advanced was not framed as defiance of the courts. It was framed as routine enforcement. The administration did not say, "We reject the judge's authority." It did not say, "The protection order is invalid." It did not openly challenge the court's power. Instead, it relied on a familiar phrase, enforcement discretion. On its surface, that phrase sounds technical, reasonable even. Governments do need discretion to prioritize resources and carry out laws efficiently. No system could function if every enforcement decision required prior court approval. But that's not what this case was about. Enforcement discretion operates within legal limits, not above them. It allows officials to choose how to enforce the law, not whether they must obey binding court orders. By leaning on the language of discretion, the government attempted to recast a judicial boundary as a managerial choice. That rhetorical move is powerful precisely because it sounds boring. It shifts the frame from rights to logistics, from constitutional limits to administrative convenience, from "is this allowed" to "is this efficient?" And when that shift succeeds, oversight weakens quietly, because once something is framed as routine, it stops triggering alarm bells. Even when it involves detention, removal, or the use of state power against an individual, the court has already protected. This is not unique to immigration. The same rhetorical strategy shows up in other contexts: environmental enforcement, labor disputes, surveillance authorities, emergency powers. Again and again, extraordinary actions are described as ordinary administration. And when courts intervene, they are portrayed implicitly or explicitly as slowing things down, interfering, or misunderstanding the realities of enforcement. That framing subtly inverts the constitutional order. Instead of courts checking power, power becomes the baseline, and courts become the exception. In Abrego Garcia's case, that inversion is especially stark because the protection order was clear. The government did not lack a legal path forward. It could have returned to court. It could have requested modification. It could have presented new evidence. What it tried to do instead was act first and litigate later. That sequencing matters, because when enforcement precedes authorization, rights become reactive rather than proactive. People are protected only if they can stop harm in time, not because the system prevents harm from occurring in the first place. That's not how the rule of law is designed to function. And this is where rhetoric becomes more than just words. When enforcement authority is framed as default and judicial review as optional, the public begins to internalize that hierarchy. Courts start to feel secondary. Compliance feels conditional. Over time, that changes expectations, not just inside government, but among citizens themselves. That's why cases like this are about more than a single detention. They're about whether legal protections are treated as firm constraints or as speed bumps that can be navigated around when no one is looking. One of the easiest ways to underestimate the significance of the Abrego Garcia case is to focus on its scale. This was not a mass deportation order. It was not a sweeping policy change. It did not affect thousands of people at once. It involved one man, and that fact can make the story feel small, even insignificant, especially when compared to larger immigration battles or headline-grabbing executive actions. But in constitutional terms, cases like this are often the most revealing, because they show how power behaves when it thinks no one is watching. Large policies attract attention. They generate backlash. They invite litigation. They force the government to justify itself publicly. Individual cases don't. They move quietly, procedurally, often out of sight, and that makes them ideal testing grounds. If the government can push past a court order in a single case without consequence, it establishes a precedent in practice, even if not yet in law. It learns how much resistance it will face. It gauges whether judges will intervene quickly. It sees whether anyone notices. This is how boundaries erode, not through dramatic declarations, but through incremental normalization. And there is another reason this case matters so much. Abrego Garcia was not undocumented in the sense many people assume. He was living under a legally recognized protection. A court had already weighed the risks and ruled that he could not be removed. That means the government was not acting in a legal gray area. It was operating in a space that had already been defined and constrained by judicial authority. When executive power pushes into that space anyway, it signals a deeper problem. It suggests that protections are provisional, that they last only as long as they are convenient. That enforcement priorities can quietly override individual rights without first clearing the most basic constitutional hurdle: judicial review. That has implications far beyond immigration. Because the same logic could apply to any individual protected by a court order. A whistleblower under an injunction, a protester shielded by a consent decree, a worker covered by a labor ruling, a community protected by an environmental injunction. If those protections can be sidestepped in practice, then they exist mostly on paper, and paper rights are fragile. There's also a human reality here that's easy to miss. For the person at the center of a case like this, the stakes are total. Freedom, safety, family, stability, even a brief redetention, even the threat of it, is enough to upend a life. And when that threat comes from the same government that was ordered to protect you, the message is unmistakable. Your security is conditional. That kind of uncertainty is not accidental collateral damage. It is a consequence of treating enforcement power as superior to judicial restraint. And when the system tolerates that imbalance, even once, it teaches the wrong lesson. It teaches that rights are negotiable, that courts can be bypassed, that limits are suggestions. That is why this case matters, not because it is large, but because it is precise. It shows us exactly where the stress points are. What ultimately stopped the government in this case was not public pressure or political backlash. It was the court, specifically a federal judge who looked at the facts, looked at the existing protection order, and concluded that the executive branch was attempting to move too quickly and too far without judicial approval. That intervention matters, not just because it protected Kilmar Abrego García in the short term, but because it reaffirmed something increasingly fragile in American governance, that courts are not optional participants in the exercise of power. In granting the temporary restraining order, the judge did not resolve every legal question. That's not what a TRO is for. Instead, the court focused on a narrower, more urgent issue: whether allowing the government to proceed immediately would cause irreparable harm and undermine the court's ability to meaningfully review the action later. The answer was yes. If Abrego Garcia were redetained or removed before the legal issues were examined, the court's authority would be reduced to symbolism. The protection order would exist in theory, but not in effect. That is exactly the scenario courts are designed to prevent. What's striking about this ruling is how basic the principle is, and how often judges now have to restate it. The executive branch does not get to decide unilaterally when judicial oversight applies. It does not get to treat court orders as hurdles to be navigated around rather than commands to be obeyed. And it does not get to reframe defiance as efficiency. Yet judges are increasingly being asked to intervene at precisely that level, not to make policy, but to slow the machinery of the state long enough to preserve the possibility of lawful review. That's not because courts are becoming more activist. It's because executive power is becoming more impatient with constraint. When agencies push the outer limits of their authority, courts become the last line of defense by default. They are forced into a reactive posture, issuing emergency orders not because they want to, but because the alternative is irreversible harm. And that pattern carries a cost. Temporary restraining orders are blunt instruments. They are issued quickly, often on incomplete records, because time is the one resource the court does not have. They are necessary, but they are not ideal. In a healthier system, the government would pause before acting, seek clarification, and return to court when legal authority is genuinely in question. In this case, it didn't. The judge's response, therefore, wasn't just corrective, it was preventative. It was an attempt to reassert the sequencing that constitutional governance depends on: law first, action second. That may not sound dramatic, but it is foundational. Because when courts are forced to constantly reimpose limits that should already be respected, the system is under strain. And when those limits are respected only after a judge says stop, the rule of law is no longer automatic. It's conditional. This ruling pushed back against that drift, not loudly, not permanently, but decisively in the moment where it mattered. It would be easy to treat this case as a narrow immigration dispute. One person, one protection order, one temporary restraining order. But that framing misses what's actually being tested here. Because the legal logic the government advanced in Abrego Garcia's case does not stop at immigration enforcement. It reflects a broader posture toward executive authority, one that shows up wherever agencies believe speed, control, or political pressure justify bypassing judicial limits. At its core, this case asks whether individual protections granted by courts are durable or merely provisional, subject to administrative override. That question matters everywhere law restrains power. Environmental law relies on injunctions to stop irreversible harm, while courts evaluate compliance. Labor law relies on court orders to protect workers from retaliation during disputes. Civil rights law relies on judicial intervention to prevent discrimination before it becomes entrenched. In all of those contexts, the logic is the same. Courts act as brakes, not because they oppose enforcement, but because enforcement without limits can destroy the very rights the law is meant to protect. If executive agencies can reframe court orders as temporary inconveniences, something to be navigated around rather than obeyed, then every area of law that depends on judicial protection becomes weaker. What makes this especially concerning is how quietly that erosion can happen. There's no dramatic declaration that court orders no longer apply, no formal suspension of judicial review, just a series of routine actions justified as discretionary enforcement taken before courts can intervene. Over time, that behavior shifts expectations. Officials begin to assume they can act first and litigate later. Courts are forced into emergency posture more frequently, and the balance of power tilts, not because the law changed, but because practice did. That's the danger this case exposes. Not a single unlawful act, but a mindset that judicial protections are obstacles to be managed rather than boundaries to be respected. And once that mindset takes hold, it spreads. It becomes easier to justify ignoring injunctions just this once. Easier to frame compliance as optional when political stakes are high. Easier to portray judges as meddling rather than essential. This is how institutional authority erodes, not through defiance, but through normalization. Abrego Garcia's case brings that erosion into focus because it's so starkly personal. There's no ambiguity about the harm, no diffuse policy impact, just a protected individual whose safety depended on whether the government would respect a court order it found inconvenient. That clarity makes the principle harder to avoid. If courts cannot reliably protect individuals when they grant protection, then the promise of the rule of law becomes conditional, available only when the executive branch agrees to honor it. That's not how constitutional governance is supposed to function. Courts do not enforce their authority through force. They enforce it through legitimacy, through the expectation that their orders will be followed without coercion. When that expectation weakens, every right enforced by a court becomes more fragile. This case matters because it reminds us that the rule of law doesn't fail all at once. It fails quietly when limits are tested in small technical ways, and no one is paying attention. To understand why Abrego Garcia's case matters so much, it helps to step back and look at why judicial limits on detention exist in the first place. Because the idea that courts should restrain executive detention power isn't a modern invention. It's one of the oldest principles in constitutional governance. The founders were deeply suspicious of unchecked detention authority, not in theory, in lived experience. They were shaped by a British system where the Crown could imprison people without trial, without explanation, and without meaningful recourse. Arbitrary detention was one of the abuses that pushed the colonies toward independence. That history is why the Constitution explicitly protects habeas corpus, the right to challenge unlawful detention, and allows it to be suspended only in the most extreme circumstances, like rebellion or invasion. Habeas corpus isn't a technicality. It's the legal mechanism that forces the government to explain itself when it takes away someone's liberty. And critically, it places that explanation before a judge, not an agency supervisor, not a political appointee, not an internal review board. That design reflects a core insight. The same branch that detains people cannot be the final judge of whether detention is lawful. Over time, that principle has been reaffirmed again and again. Courts have consistently held that even during periods of heightened national concern, war, terrorism, mass migration, the executive does not gain unlimited authority to detain without judicial oversight. In case after case, the Supreme Court has emphasized that the rule of law does not disappear in moments of perceived urgency. It becomes more important. That doesn't mean the executive branch lacks enforcement power. It means enforcement must operate within boundaries defined by law and enforced by courts. Temporary restraining orders are part of that system. They exist precisely because detention and removal can cause irreversible harm. Once someone is transferred, deported, or disappeared into administrative custody, judicial review becomes far more difficult, sometimes impossible. So courts act early, not to block enforcement permanently, but to preserve their ability to decide the legality of that enforcement meaningfully. In that sense, a TRO isn't judicial overreach, it's judicial self-defense. It protects the court's role as an independent arbiter by ensuring that the subject of the dispute is still within reach of the law. When executive agencies push against that mechanism by acting first or by treating court orders as flexible, they aren't just challenging a particular ruling, they are challenging the constitutional architecture itself. The separation of powers only works if each branch accepts limits. It does not get to define unilaterally. Courts do not command armies, they do not control budgets. Their authority rests on compliance, on the shared understanding that when they issue lawful orders, those orders are binding. If that understanding weakens, the entire structure becomes unstable. That's why cases like Abrego Garcia's resonate beyond their immediate facts. They test whether the oldest safeguard against arbitrary detention still functions in practice, not just on paper, and they force a question that every constitutional democracy must answer repeatedly. When liberty and authority collide, who gets the final say? The Constitution's answer has always been clear. The courts do. It's easy to look at a case like this and think it's narrow. One man, one order, one judge. But that instinct to minimize is exactly what allows power to drift, because the most consequential changes to democratic systems rarely arrive all at once. They arrive through repetition, through normalization, through moments when something improper becomes merely disputed, and then routine. Abrego Garcia's case matters because it sits at that fault line. A court issued a clear protection order. The executive branch attempted to move anyway, and a judge had to intervene, not to create new rights, but to enforce ones that already existed. That alone should give us pause. In a healthy system, court orders don't need emergency reinforcement. They are followed as a matter of course. When they aren't, it signals strain, not just between branches, but within the norms that make the system function. What's encouraging here is that the judiciary did its job. The judge reviewed the facts, applied the law, and said no. That restraint, quiet, procedural, unspectacular, is often the last line of defense when political incentives push toward overreach. Courts don't generate headlines by design, they generate limits, and limits are what keep authority from becoming arbitrary. But it would be a mistake to treat this as a win and move on, because the need for repeated judicial intervention tells us something important. The pressure hasn't gone away. Each time the executive branch tests whether it can bypass a court order, the system is being asked the same question again. Do rules still bind those in power? Do individual rights still mean something when they become inconvenient? And does the judiciary still have the authority and the institutional backing to enforce those answers? Those questions aren't theoretical. They show up in detention centers, in immigration courts, in environmental enforcement, in labor disputes, in civil rights cases. They show up wherever the government exercises power over individuals who lack political leverage. And that's why this story deserves attention, even if it never trends, because democracy doesn't only fail in dramatic moments. It erodes when safeguards are treated as optional and when resistance to oversight becomes habitual rather than exceptional. In this case, the court reminded the executive branch of a basic truth. Authority is not self-justifying, it is bounded. And those bounds matter most when they protect someone with the least power to protect themselves. A judge said no, not to law, not to enforcement, but to the idea that power gets to decide when the law applies. That's not a headline-grabbing moment, but it's a foundational one, and it's worth paying attention to. There's a reason this case keeps pulling us back to one simple word: no. Not shouted, not dramatic, not ideological, just no. A court saying, you don't get to do that. Not this way, not without review, not without respecting the limits already in place. In a moment when power so often moves by pressure and momentum, that kind of restraint matters more than it appears. Because the rule of law doesn't survive on good intentions. It survives on enforcement, on compliance, on the shared understanding that when a judge issues an order, it carries weight, even when it's inconvenient. Kilmar Abrego García did everything the system asked of him. He sought protection through the courts. He received a lawful order. He relied on it. And when that protection was threatened, the judiciary stepped in again, not to expand rights, but to prevent them from being quietly undone. That distinction is crucial. This wasn't judicial activism. It wasn't policymaking. It was maintenance, the kind of maintenance that keeps democratic systems from drifting into something else. And that's why this case shouldn't be framed as a technical immigration dispute or a procedural skirmish between lawyers. It's a reminder of how fragile protections become when enforcement power starts treating judicial limits as suggestions instead of obligations. It's a reminder that individual rights don't defend themselves, and it's a reminder that courts, for all their flaws, remain one of the few institutions designed to slow power down long enough for the law to catch up. A judge said, "No here." That doesn't solve everything. It doesn't end the pressure, and it doesn't guarantee future restraint. But it does reaffirm something essential, that the government still has to answer to the courts, that orders still mean something, and that rights don't evaporate just because enforcing them is inconvenient. In moments like this, democracy doesn't announce itself. It whispers, through process, through restraint, through a single word holding back something larger: no. And for now, that still matters.
Thanks for spending a few minutes digging into this with me. If you want more grounded, progressive commentary without the outrage bait, subscribe and stick around. Every time you watch, share, and engage, it helps build a community that believes democracy is worth understanding and defending. I'll see you in the next video.